Carter Napier with the City of Casper. I am the city manager there. Municipal staff and elected officials should always keep in mind that municipal business is public business and that the public has the right to know how its servants are conducting their business. City or town council members serve their communities at a crucial place, the level closest to the people. Without the informed trust of these people, democracy is jeopardized. That being said, it is always the best practice to conduct the maximum amount of the public's business in public. In 1973, the Wyoming State Legislature adopted the Public Meeting Law, which is better known as the Wyoming Open Meeting Law, Chapter 16, Article 4 of the Wyoming State Statutes. The Wyoming Open Meetings Law, which applies to all agencies and divisions of Wyoming, except the state legislature and judiciary, defines meeting as an assembly of at least a majority of the governing body of an agency, which has been called by the proper authority of the agency for the purpose of discussion, deliberation, presentation of information, or taking action regarding public business. An assembly means communicating in person, by telephone or electronic communication, or in any manner that allows all members to speak with each other simultaneously. Proper authority would normally be the mayor or someone called upon by the request of two or more members of the governing body. For the purpose of means, the intent of a meeting must be for the purpose of discussing, deliberating, presenting, informing, or acting on public business. According to the Wyoming Open Meetings Law, all meetings of the governing body of an agency are public meetings, open to the public at all times. Exceptions to this rule are executive sessions. When special meetings are called, notice of a specific time and place must be provided to the public and the media, as well as information on what business will be transacted. No other business can be considered at this meeting. When an emergency meeting is required, all reasonable efforts must be made to provide the public with notice. In order to go into an executive session, the governing body must first convene a regular or special meeting where a motion that states the statutory reason for going into executive must be accompanied by a majority vote. Executive sessions may be called for these reasons: to consider appointment, employment, or dismissal of employees, for salary negotiations, to select a site for real estate when the publicity regarding this consideration could cause a price increase, and for litigation the governing body is a party to. There is no requirement for recording discussions, but for all meeting types, governing bodies are required to record minutes, even when no action is taken. This includes executive sessions, where minutes and proceedings are recorded but remain confidential, and are produced only in response to a valid court order. If information from an executive session is otherwise disclosed to the public in violation of the Ethics and Disclosure Act, the member of the governing body who inappropriately made the confidential information public is subject to penalty and removal from office. Action means a transaction of official business of the governing body, including a collective decision of a governing body, a collective commitment or promise to make a positive or negative decision, or an actual vote by the governing body upon a motion, resolution, rule, order, or ordinance. No action can be taken by a governing body except during a public meeting. Some governing bodies erroneously assume that as long as no action is taken, there is no lawful meeting. But meetings are not limited to a formal meeting. They include informal conferences or sessions of members of the governing body that are held for the purpose of discussing public business, whether a decision is made during that gathering or not. For example, governing bodies hold work sessions, presentations, or retreats where no formal action is intended to be taken. Under the Wyoming Open Meetings Law, these gatherings do constitute meetings as defined by law. As such, They must be preceded by a public notice, and they must be treated the same as any other special meeting. A meeting may also include gatherings of members of the governing body who are in communication by means of a telephone conference or an online discussion. Most legal counsel would advise against discussing business in such informal settings to avoid the appearance of illegality. Compliance with the open meetings law is a serious matter. The best practice is to conduct the maximum amount of the public's business in public.